A very good afternoon to all my dear students. I'm very happy to have all of you back in the class, and I hope you had great LLP sessions. Good afternoon, Mr. Sandeep, Gopal Mishra, Purva Joshi, Manish, Ritu Tiwari, Nidhi Yadav, Gopal Mishra, Manisha, Nikita, Soumya Ranjan, Shriya, Mr. Kevin. Mr. Kevin is saying, I'm worried the syllabus is getting wide. What do I do? I'm really getting tense. So, Mr. Kevin, there's nothing to get tense. It's actually a very true feeling. That means you have started studying. That's why you are now able to gather the information that there's too much information. So, being consistent with your studies and revising on a continuous basis is going to help you a lot. So don't worry, Mr. Kevin. At the end of the sessions, I'll help you how you have to make a timetable and how you have to keep revising. Miss Ananya Kumari, Shriya, good afternoon, children. Aishwarya, Swati, Arpi, Darshan, so many of you today. Tamanna, Bhumi, Simran, Rishita, Natasha, Adishri, Surya Kumari, Mr. Nishit, good afternoon, children. So all of you know which act we're going to start today. So you see a foundation law subject is going to come into an end. We have 3 sessions, and quickly tell me the name of the act which is left, which we are going to do today. Miss Shri, yes. Even I'm very happy to see all of you. Good afternoon. All right. Sapna Chaudhary. Definitely, we'll be discussing about the timetable. So your glitches and worries that are coming in between will get relaxed. All right. Ashwini, Rishita, Bhumi, Dadit. Good afternoon, children. So quickly tell me the name of the act. Meanwhile, I'll just take out the presentation. So I know you all are excited for the last act. So children, worry, I have always been telling you, if we just keep worrying, then the things will keep getting difficult. What we have to remind ourselves and what we have to remember is that we always have to be happy while studying law. The moment I say, oh God, it's tough, I have sent all the negative energies to myself. The moment I open my study material, children, study material is the Bible for all of you. We are not going to leave a single line from the study material. You have to complete entire thing, whatever we have been marking, whatever case laws we have been doing from the study have to be done then and there itself. And I hope you all are making your notes, presentations, your notes that we're discussing in the class, and study material is sufficiently enough for your completion of syllabus. All right. So very rightly, you all have mentioned, ma'am, we are now going to start with the Companies Act. That's absolutely correct. So we move towards a foundation law subject, that is Companies Act 2013. So children, we have already done Indian Contract Act. We have understood how the contract is formed, how the offer acceptance, all the essential elements. And then I taught you how out of the Contract Act, sale of goods and partnership was taken out and a separate act was formed. Now, what is the meaning of company? All those worries, it's getting huge and huge, it's getting too long, too much. That's why we have to understand that why we have reached at a level of companies. कंपनी आई कहाँ से? हम एक ऑर्गेनाइजेशन बनाते हैं, सोल प्रोप्राइटर पढ़ लिया हमने. तो मैम, you taught us that when Ram is an employee who is joining me, then we pay salary to him. Remember when I told you that you're a sole proprietor and you have hired an employee to whom you're paying a salary? He will never be a partner. He is a salaried employee. So you were a sole proprietor at that time. So you thought Ram is really doing well with us, and why don't I make Ram join as a partner with me? So if he joins as a partner with me and we have 2 partners, then what type of organization we have opened? We have opened a firm. We have opened a partnership organization. We have incorporated a firm. Together, you and Ram will be known as firm. Tomorrow, if both of you leave that organization, you just close, you just dissolve the firm, will the firm continue or it will come to an end? Let me take your test. Let me see how well you have been revising. So if you and Ram were the only 2 partners and you have left, what will happen? Will the firm continue or it will stop coming into existence? Excellent. The firm will come to an end. Dissolution of firm involves dissolution of partnership. That's wonderful. Mr. Nishant Shaika says, I easily remember sale of goods in Indian partnership thanks to you. Thank you to you for revising. That's the excellent reason, Nikshit. That's why you have been able to remember the entire text. Miss Samina, all right. So who is going to give me the answer for this one? Partnership. Vaishnavi Chaudhary, don't worry, your books will come. Nothing to worry in this. This is an admin related query. You can address to ICI directly about that. Good afternoon, Sarthak, Aditi, Iram, Lisa Jain, all those who have joined. Miss Purva Joshi, Aditya, Yash, Vaishnavi, all your answers are absolutely correct. The partnership will now come to an end. All right. So now, after that, what happened? We understood that partnership was having one major drawback. So me and Ram have formed the partnership, and now we're not going to end it. We are just continuing. We're not going to dissolve it. But we were having one major drawback. It was very easy to set up the partnership. There was a lot of flexibility of the agreement that we have formed. But there is one drawback which is really bothering me. What was that drawback? Who is going to answer me? What was that drawback? Yes, it will become a sole proprietor if only one partner goes. Mr. R.N. Kumar, excellent your answer. Partnership will come to an end. Rathik says, Richa Kumari the same. Great. What will happen? What was the one drawback that we were facing in the Indian partnership? Right? Unlimited liability, mutual agency. Try Shrang Sichang says mutual agency. Was mutual agency a drawback? No, that was not a drawback. The major drawback that we were facing is unlimited liability. Excellent. R.N. Kumar is combining the unlimited liability with the mutual agency. All right, then it's excellent. So because of that mutual agency, why we were binding each other? Since if I do something, I hold you as a partner also liable. When you do any actions, I am also held liable. So we were held liable for each other's action. So this is the major thing which was holding us back, and the liability was getting huge and unlimited. So that's how we thought that because of that unlimited liability, we thought of setting up another form of partnership, that is limited liability partnership. LLP was an answer to the problem that we were facing as a part of Partnership Act. So we thought of forming LLP, that is limited liability partnership. So you all have understood that LLP is a different form of partnership organization in which the liability of the partners gets limited. Now, whatever I've contributed, whatever amount I've invested in the business, my liability is limited and to that extent. So LLP gave me the benefits of flexibility of partnership along with the corporate structure of a company. Remember, children, partnership, it was not compulsory to get yourself registered, but under LLP, you must have learned that it is mandatory to get yourself registered. And the kind of structure that you get in LLP is of a company. Now, how we moved to companies was, we have understood that out of partnership, we can again have a different kind of organization, that is LLP coming up. After that, Mr. Ram and the other partner who were together doing the business and another partners that have joined them during the course of time wanted to expand the business at a more larger scale. So we started as a sole proprietor. We hired an employee. We turned him into a partnership. We joined and to partnership converted into LLP just to take the benefits of the limited liability. Now, if you want to expand the business, you have further more options. Either you can open a private limited company, or you want the public at large to invest in the shares, you can also open a public limited company. So that is how the company form of organization came into existence, to have a business at a larger scale, to get a legal existence. So partnership registration was not compulsory. Remember, children, There we taught you that registration only to have those 4-5 benefits where you want to sue the third party or you want to file a case against each other, partners fighting with each other. In order to take the benefit of those kind of resolutions, you can get yourself registered and registration give you major benefits. But under company, under LLP, registration has to be done. It's a must. You get a legal existence. That means you are existing in the eyes of law. As a partnership, you only all told me if all the partners died, firm comes to an end. It's closed. But does it happen in the case of company? If all the directors, shareholders of the company die, what will happen? The company will get a perpetual succession. We'll understand all these features, these silent features when we do today. A most important feature of companies is your separate legal existence and the perpetual existence. All right. So that is how companies were formed. That is how when we want to expand the business at a larger scale, we start with a single proprietorship and then ended into partnership, and then we expanded into setting up a large scale organization, that is setting up a public or a private company. So today we are going to understand the features of the company. What all features? They must be very similar to what you have done under LLP as well, but there are few features that are different, which are just given to the corporate structure of a company. Then we have a very important theory, that is corporate veil theory. What is the meaning of veil? Veil means a shield, a curtain which is existing between the shareholders and the company. So if there are 5 shareholders and they have formed a company, there is a shield, there is a curtain which is existing between both of them, which generally separates them. So company is different, shareholders are different. Company's liabilities are different, shareholders have their own set of liabilities. So this is the major difference from the other form of organization. Other organization, if you are running a shop, you are the shopkeeper, you're also responsible for your business. Nobody else is going to take care of that. You only have to take care about the employees you have hired, about the trading material that you have bought in your shop, and whatever you're selling, whatever revenue you're earning, you are the sole proprietor. You are into partnership. Together, you are taking care of that business. But if you form a company, your company is different, although it is being run by you only. So when I say a company gets an artificial existence, does it mean that somebody come into existence? Some corporate person comes into existence, that person starts walking and talking. Will the person take care? No, ma'am. Obviously, the company will also being run by the human agency. There will be human body who are running the company, but the company has its own legal existence. The thappa that you get, the common seal that you get from the registration department is something that makes you as a registered company. All right. So are we connected? Vinu sir. So I want to ask one thing. All right. So I want to ask something to you. I just want to cross check that the windows which is appearing on that, it's showing the same windows on the screen here. But the admin panel, you want me to open it separately? The queries are also getting visible, yes or no? Okay, because it was showing to me that it's visible. All right, so can we continue, sir? All right. Okay, students. So corporate veil theory that we were just talking about, there is a separate shield between the company and the shareholders. That is what we have to understand. There is a huge case study which we're going to do in that. After that, we have classes of companies. Classes of companies, children, means types of different companies. Share capital and shares. That is again something which you have done under part of accounts also. You all know now what are shares, what are debentures, how you invest and how you bring in the capital in a company. And at the last, we will be discussing about the memorandum and articles of association. So if you ask me what is memorandum, memorandum is the charter of the company. It is something which tells all the bylaws, all the rules and regulations, how the company is formed, what is the object clause, what is the name of the company. Each and entire detail is given in the memorandum of association. Like you formed partnership deed. What was the part of partnership deed? What does it used to tell you? Partnership deed, you will tell us how the partnership organization is formed, right? Ashutosh Purva, I hope now the voice is clear. All right, Vadikar Baba Saheb, you have not missed much. It's okay even if you have joined late. Unlimited liability, firm's liability. All right, fine. Fine, students. Let's continue. Yes, so memorandum will tell us about all these. So partnership deed, yes, I'm asking you what does partnership deed tells us? So partnership deed will tell us about the name of the partners, place of the organization, when does it started, date of joining, all the details like they're giving in the partnership deed about the partners. The same way memorandum of association tells us about all the nitty-gritties and details about their companies. Articles of association will again tells us about the rules and regulations, how the company is going to be run, what are the how the meetings are going to be held, who are the shareholders, how they will be acting, how the first directors will be appointed. All this detailed study will be given in the articles of association. So this is what the basic agenda of your Companies Act, which is divided into 3 lectures. And in the last one, the 3rd lecture, when we discuss in detail about your memorandum and articles, we'll also be taking up your all the query questions, all your mock test papers, as well as your timetable agenda, how to fix up the revision for law. Now, coming back to the introduction of Companies Act, children, as I keep telling you, you cannot leave a single line from your study material. So this is just the summarized paragraph from your study, just to give you an integral idea about what all is given in the Consolidated Act of Companies Act 2013. If you ask me, we have to learn all these 470 sections in 7 schedules in CA Foundation itself, the answer is no. This is the entire summary, what it is trying to tell you. The Companies Act 2013 has 470 in totality the sections. So these sections are divided. Few things you'll be covering now in CA Foundation, and the major part of companies law will be covered under CA intermediate course. 7 schedule, 29 chapters, and substantial part of this act is in the form of companies rules. Now you remember I told you when we were discussing partnership, the number of partners, I told you it has been limited to 50 as mentioned in your company's rule. So the rules are amended from time to time. They tell us about how the organizations have to be run, what are the features that we'll be following at the current situation. So there's a lot of disturbance at the back end. Somebody's joining, somebody's leaving. I hope there is no problem otherwise. All right. So the Companies Act 2013 was enacted to consolidate and amend the laws relating to the companies. So basically, children, before 2013, there was a major act that was known as Companies Act 1956. In order to facilitate the growth and expansion, the economy was really growing at a nice, good pace. International and national economic environment were changing. So we wanted to promote more trade, more growth, and more industrialization had to be done. So they thought of making few changes in the Companies Act, but whole of the act was completely amended. And in 2013, a whole new Companies Act 2013 was formed. So as I always tell my students, since 1956 has been entirely replaced. So if ever you try to pick up your books, which you're doing in BCom or BBO or any other reference books that you're using, please, bacha, make sure that you always refer to Companies Act 2013 and you never make a mistake of referring to Companies Act 1956. Because what we are doing is Companies Act 2013. 1956 has now been entirely replaced with this new act. All right, let's move ahead. So this is basic introduction, which you all should have a basic knowledge about. After that, we move to the definition of what is a company. So now 3 different definitions are given to you over here. You can learn any one of them, but it is important to have an understanding about each and every definition that is given over here. So the first definition is very, very simple. It says, according to Chief Justice Marshall, a corporation is an artificial, invisible, intangible, and only existing in the contemplation of law. What is the meaning of contemplation of law? Contemplation of law means only in the eyes of law. एक ऐसी चीज जो कि आर्टिफिशियल है, दिखाई नहीं देती है. इनविजिबल मीन्स इट कांट बी सीन, इट कांट बी फेल्ट, and only in the eyes of law it is existing. So when you generally say in the eyes of law, वो कहते हैं ना कानून की नजर में सिर्फ जो exist करती है, that is what we call as company. So actually it is not seen, it is not visible, but still it exists in the books of law. So if ABC have formed a company ABC Limited, so ABC are different. ABC Limited has come into existence. In partnership, ABC together form a partnership firm. They all are together. मैंने partners हैं, ये firm form करी, हम सब एक साथ. हम company के shareholders हैं, हमने company form करी. Company is different, shareholders are different. It has come into existence, although it cannot be seen or touched. But yes, the body corporate, the buildings that we form as a company, that is which it says that it exists in the books of accounts. The name of the company, once it has been registered, it has to be striked off from the registrar of companies. Then only it comes to an end. Otherwise, whether the shareholders live or die, the company will continue to exist once it is incorporated. So Chief Justice Marshall simply gave the definition that corporation is a company, company is a corporation, corporation means a body corporate, which is artificial, not a natural person. Who is a natural human being? You, me, we all are natural human beings. Okay, we're given by birth by someone, but is company given by birth? No, company is created on paper. That's why it's artificial. Human being nahi hai, but it is run through human being. That is very much correct. But it in itself is an artificial, invisible, and intangible thing which is existing only in the contemplation of law. सिर्फ कानून की नजर में, law की नजर में exist करती. Professor Hannay gives the definition, which is a very beautiful definition covering all the silent features of the company. It says it's an incorporated association, which is artificial person. Number one point is it's an artificial person created by law, having a common seal, perpetual succession, having a separate entity. So all these separate entity, perpetual succession, common seal are the features. So this basically sums up the meaning as well as the features of the company. So company always has a common seal, means if ABC Limited are the shareholders, they will together have a common seal. ये नहीं कि A Limited की अलग common seal है, ABC Limited की एक common seal बनेगी, common signature बनेगा, common authorization बनेगी. So whenever they want to sign any documents, that seal will be used for signing the documents on behalf of the company. However, the Act defines the company a bit differently. वो कहते हैं Companies Act 2013 भी define करता है company. Section 2 subsection 20 बोलता है company means a company incorporated under this act or under any previous law. So if my children have formed a company in year 1983, so it would have been formed under Companies Act 1956 because तब तो 2013 आया ही नहीं था. Companies Act 2013 तो अब आया. So it says even if any company was formed under previous law, so if company was formed under 1983 under the previous law, that is 1956 Companies Act, this Companies Act will be applicable to such companies as well. So whether you're forming the company today or under any previous company law you have formed the companies, Companies Act 2013 is applicable to each and every company. Clear? So these are the basic three definitions which you should have a fair idea about. Professor Hannay, the definition that has been given by him is the very easiest one to learn. So this is the one that you can learn for your examination. So examiner can give you define company and give the silent features. So if silent features and company is defined, you can give this definition. If you can learn the other two also, that is great. So try to put up all the three definitions if they ask you about what is a company. Applicability of Companies Act. तो अब बोले Companies Act applicable किस किसको होगा? Number one, very much clear, ma'am, any company which is incorporated under this act or under any previous company law. So if you have formed the company under previous law, then also this act is applicable. If you are incorporating the company today itself, then also this act is applicable. To the insurance companies, what does it mean? To insurance companies. Which are insurance companies? How many of you have taken insurance ever for your mobile phones or maybe for your bikes or scooters? Have you ever taken insurance? Who can tell me what is the meaning of insurance? Let me check your knowledge. So what is the meaning of insurance? What is the role of insurance companies? What do they do? Miss Mehak Roy, I will just check if the notes are there or not. But as far as I remember, all the notes have been uploaded. What's the schedules and chapters? Mrs. Aisha Tasneem, the schedules and chapters defines how the act is divided into different kind of chapters, schedules and sections. This is a part of your CA intermediate syllabus. When you go to CA intermediate, it becomes compulsory for all of you to learn about these points. As of now, you can leave the sections. No, it is not necessary to remember all the definitions and sections, Mr. Sarthak Mohanty. Yes, you can write this definition, Miss Manisha, one of them. Companies Act will be applicable to Indian companies or world companies. So Alfie Thangal, we are talking about the Indian companies. When we do foreign companies, to that foreign company which is incorporated in India or having a place of business in India, to that also Companies Act 2013 is applicable. Yes, insurance helps us to recover the damages. Very good, Mr. Nabeen. Shreya says providing protection. Survey says it is a security against the goods which have been secured. Insurance policy is taken for the loss occurring in future. Excellent, Alfie Tangal, Survey, Ashwani, Bhumi, Nabeen, Punjabi, SF. It's a premium. It's a premium that you're paying. So you pay the premium and you get the insurance cover. Receiving claims, Simran, good. Abhishek, Tamanna, now your answers are coming. Very nice. Bharat, Shreya, Mahavir, Abhishek, Tamannapati, Nikita, all of you are correct. So insurance can be for life insurance also, but here it is talking about the insurance companies. So it says actually, when you form any company which is doing insurance business, so basic idea, you know what is insurance. So if, say for example, you have purchased a mobile phone and they generally tell you that you're purchasing an iPhone of 1 lakh plus worth rupees. So now if you want that tomorrow, if you get lost or something happens to this, so you want to get it insured. So you'll be paying a premium to the company on a regular basis. And if any mishappening happens, the company will give you the insurance payment, the cover of the insurance money, that your money will not go waste. It has a security which has been provided by the insurance company. Now, the insurance companies actually are formed by the Insurance Act. अगर मैं कोई इंश्योरेंस कंपनी फॉर्म कर रही हूँ तो विच एक्ट आई हैव टू फॉलो चिल्ड्रन आई विल ऑब्वियसली फॉलो द इंश्योरेंस एक्ट 1938 और द IRDA एक्ट दैट इज इंश्योरेंस रेगुलेटरी डेवलपमेंट अथॉरिटीज एक्ट 1999. But then why it is saying Companies Act is applicable? It says except where the provisions are inconsistent. So wherever the provisions are not consistent, there my only specific act, that is Insurance Act, is applicable. But how the company has to be set up, what is the concept of separate legal entity, what is the meaning of common sale, all this will be defined under Companies Act 2013. So it says one Companies Act 2013 has been formulated. Now all the banking companies, insurance company, electrical company, all these companies, although they have their own separate act. So banking company is regulated by the Banking Regulation Act. But where the provisions are inconsistent, where you're not sure that which provision has to be followed, please refer to the original Companies Act 2013. So the major applicability to every company is Companies Act 2013. But where you have your individual companies, for example, ICA body itself, Institute of Chartered Accountants of India, they are incorporated and run by the ICA Act that we have. So every individual body have their own respective acts and they have to follow the provisions. But wherever the provisions are inconsistent means wherever the provisions are not matching with each other, there you have to blindly follow the Companies Act 2013. Or any other government, any other company which is governed by any special act for the time being in force, that company has also to be registered and has to be seen for the applicability and provisions of the Companies Act 2013. Clear ho gaya? All right. Let's move ahead. So these are the salient features of the company, how the company is formed. We will understand how the formation of company happens. But first, let us see what are the basic features. We have defined the company. We have understood the applicability. It is applicable to insurance companies, banking companies, electricity generation companies. So all these electricity departments, which they have the company for the supply of electricity, they have to incorporate themselves under the Companies Act 2013 itself. However, they have their separate electricity department and Electricity Act 2003, which tells how the principles, how the supply of electricity has to be done. So how my insurance premium will be calculated, how the insurance cover has to be given, that Insurance Act is going to do. But all the provisions related to the silent features, that is how the company will be formed, has to be covered under Companies Act 2013. Now, the first silent feature says it's a body corporate. So ये टाटा की बिल्डिंग दिख रही है आपके सामने, इसकी the huge buildings, Infosys and other buildings. What are these? They are trying to show you the body corporate. So I have come into an existence as an individual person, and the body which I'm wearing is a corporate body. Somebody was asking, ma'am, robot is an artificial person. So here we are not going into a robot. You are not babies now. You're all grown up. So you don't have to compare the company with the robot. You have to understand what is the company. It comes into existence. जैसे कि बढ़िया सा उन्होंने बिल्डिंग दिखा दी कि ये जी देखो कंपनी हमारी बन गई है, हमारी कंपनी खड़ी हो गई. तो इसका मतलब ये नहीं कि ये कंपनी अपने आप में ही सब कुछ कर रही है. If you can see, the lights are on and the students and the people like you will be sitting with the laptops and doing the work and running the company together. So all the shareholders and directors although run a company, but company has its own body corporate structure. The body of the company is of a corporate legal existence. It has its own separate artificial existence. It is not that the shareholders are known as company. Company is different, shareholders are different. Likh lo ye line. Please note down, all of you. Company once comes into existence. Company when come into an existence is different from its shareholders. So Ms. Shriya Modi, only where the provisions are inconsistent means wherever our provisions are not matching, they're overlapping, there you have to refer to the Companies Act. Otherwise, for banking, you will specifically refer your Banking Act itself. Okay, fine. All right. So what is the meaning of perpetual succession? So there were three, not partners. So there were three members. We never called the members of the company partners. Partners are known under partnership. And under company, we call all the people who are working in the company are known as members. The members are either the shareholders or the directors. So there were 5 shareholders and 2 directors who were returning from their meeting from Bombay to Pune. And they met with an accident and they all died. And they have set up a company that is known as ABC Limited Company. Now, children, since 3 directors, 3 shareholders and 2 directors who were the part of company, they were together running this company. Now, if 5 of them have died, will the company come to an end? Yes, ma'am, or no, ma'am? What will happen with the company? Will it come to an end? Yes, it's an individual body. That's correct. Ritu Tiwari, individual body means it's an individual who has a body corporate structure. So it does not have an individual structure. The structure is like of a company. एक building बन जाती है जो company खड़ी हो जाती है. Vaishnavi Chaudhary is still wondering. So I have already answered. Insurance is a contract between, all right, that's absolutely correct. Insurance definition that you've given. But for the books that you were asking, for that you have to address to the ICI directly. All right. Perpetual succession is clear, children. So you have to tell me that if all the shareholders and directors who are returning from their way back in the meeting from Bombay to Pune, will the company come to an end? Yes, ma'am, or no, ma'am? Perpetual succession means the success of the company. Miss Punjabi Asif, no, it does not mean the same. It means that the company continues to exist whether the members are there or not. No, ma'am, the company still exists is the correct answer. Kevin, Tamanna, Richa, Shwarya, Nidhi, Manish, Nikshit, Sarvesh, all of you have given the correct answer. Aisha, Sood, Swati, Giri, Richa, that's absolutely correct. Why? Because company will not come to an end as it has a perpetual succession. So please write down the meaning. Perpetual means continuous. Continuous succession means it's continue to exist. A company will continue to exist whether the shareholders and directors of the company survive or not. Whether the directors or shareholders of the company survive or not. So even if all the shareholders have died, so even if all the shareholders and directors of the company have died, so even if all the shareholders and directors of the company have died, the company still continue to exist. The company still continue to exist. All right. Now, this is what you have written under perpetual succession. Perpetual का मतलब होता है continuous, succession का मतलब होता है existing, continuity in existence. So how the company will come to an end? You have to get its name striked off from the registrar of companies. Then only it will come to an end. So the third point is again a very, very interesting point. This is a whole full-fledged case law, which we'll do from the study material. So after the break, when we meet this particular case law, we'll read from the study material. As of now, just understand there is a separate legal entity. So you individuals, shareholders, you are different and the company is different. ये मैंने शुरू में भी आपको बता दिया था. ये लोग एक चीज नहीं है, ये अलग-अलग है. कंपनी को रन कर रहे हैं, कंपनी के मालिक भी हैं. But the company is different, shareholders are entirely different. After that, it is artificial legal person, which means that the company can own the property, company can sue and be sued. So now, since you have incorporated a company, company has its own legal existence. Say, for example, ABC Limited. So now you want to purchase any property, the company can have the property in its own name, ABC Limited company, the papers are there. Company can be sued also. If you company can be sued. You want to take any, you want to file a case against the company, then also you can file the case in the name of the company. Okay, so anyone wants to file a case against this company. So you want to file an action, then also you can send the notice at the address of the company. So it's not that I have to search who are the shareholders. Say, for example, any XYZ Limited company has made any, done any fraud. So you can directly send the papers to addressing to XYZ Limited. You can sue the company directly. You can send notices at the name of the company. Entering into contract. Now, since it has come into existence, you can see these papers. So the company's name has come into existence on these papers. So now you want to sign into any contract, you can sign the contracts in the name of the company itself. Say, for example, ABC Limited entering into contract with Mr. Rajkumar. So the company is entering into contract rather than me as a director coming and entering, my company will enter direct contracts. So ABC Limited was entering contract with Mr. Rajkumar for the rent agreement. So if I want to take any, the building that I've taken on the rent for my company, so the company's name will be there on the rent agreements itself. But the main interesting part, it acts through human agency. Can the company go on the streets and do the business? Who is going to do the business? The people who are behind the company. Human agency के बिना company नहीं चल सकती. लोग तो हमें चाहिए ही चाहिए, तभी तो company चलेगी. So वो कह रहे company की artificial legal existence हमने कर दी. Legally it has come into existence, but it is artificial. It cannot move on its own. You need human agency. You need people behind the wall who are going to run the company. All right. That's great. So Macora versus Northern Assurance is another case law. But before that, we have common seal also. So what is the meaning of common seal, children? That means the common signatures. So together we have the signatures of the company. आपने देखा होगा कई बारी आपके लेटर हेड्स होते हैं कंपनी के एंड उसके ऊपर साइन करा होता है. If any one of you have chartered accountants in your family or any organizations, you can visit or maybe just try scrolling down on the Google just to see how the common seal papers are signed. So if you'll see the major important documents, they have this stamp paper signatures of the company itself. So together, when we put the signatures, common seal is nothing. It is just the authorization. It is the signature. So there is another very interesting amendment. अच्छा, एक चीज बहुत जरूरी, children. You will never leave the amendments. So most of the amendments came in the year 2020 also, 2021 also, there were few amendments. So we'll try to cover all the amendments. Most of the time amendments is again a basis for the examiner to ask the questions so that it should be seen that you are lastly properly updated. So common seal has another amendment which we will be doing from the study material also. As of now, I can simply tell you. So if you have two directors in a company, those two directors should be signing the authorization Or if a company has a company secretary, then one director and one company secretary has to sign all the official documents. Now, in the latest amendment, this is something which has come up. Another concept of limited liability. So unlimited liability was only part of your partnership, which was really bothering you a lot. All the partners were personally liable, but here we are joining hands. We are part of a company. We have invested huge and huge capital. We have bought the public also into interest. We have subscribed the shares, but our liability is limited. How the liability is limited? The liability may be limited by shares or limited by guarantee, or there are even companies which are unlimited liability companies. So different companies have their different liability structure. So how I have to pay my liability to the outsiders is decided about the type of the company that I am into, whether it is a company limited by shares, company limited by guarantee, or the unlimited liability companies. All right, so these are the 6 features which we have to understand. Meanwhile, let me just go through your queries, if any, and then we'll open the study material. Yes, Manish Jain, it's separate entity. That's absolutely correct. Mr. Aryan Kumar is asking if the shareholders legal here will become shareholder, then they can appoint new directors. So how are you going to run the company? That is absolutely upon you. If the shareholders have died, the legal heirs are going to take up. But there my question was, child, whether the company comes to an end or not. So the answer to that question is no, ma'am, the company will continue to exist unless and until we wind up the company, we strike off its names from the registrar of companies. Unless and until we have not done these activities, the company will continue to exist. All right, Kevin is right. Perpetual succession will take place. That was correct. All of you are correct. It means continues. How can we sue against the company? Mr. Nikshit, so if I want to file a case against the company, so you are a director of a company, Mr. Nikshit is a director of MNQ company. So now I can simply send a papers, I can send a notice at marking, addressing it to MNQ Limited. I don't have to specifically search that this is the director to whom I have to file a case. I will sue the company in itself. So all the shareholders and directors will come into the picture for that. If a particular director has done something wrong, then we have to mention that clause. That's absolutely correct, Mr. Kevin. Articles of association, when we do the last topic, there I will teach you how you can hold the particular directors liable for the frauds that they're doing. So children, there is another picture which comes, abhi hum separate legal entity mein samjhenge that when you have a different concept, when the company is different, shareholders are different, I am saying that the company can be sued. But at times this shield, this curtain that we have given might be lifted and we try to hold the shareholders also responsible. So although since beginning, I've been telling you that company and shareholders are different, they will still remain different. But in order to protect the interest of the shareholders, in order to protect the interest of the, promoters and investors who are investing huge money in the company, their interest and stakeholders' interest has also to be taken care of, so that tomorrow, if anyone tries to cheat, and say that, we are going to protest, we are not going to accept this case because it might be the shareholders who are doing, companies different, shareholders are different. So law said in order to hold those shareholders liable so that the innocent investors can be protected, there in few cases, if any fraud is being done by a company, in that very case, company and shareholders will be considered as one people. All right. So all these cases, when we discuss corporate veil theory, then you will understand. So let's take a small break over here and then we'll continue. Meanwhile, just go to the definition and features from the study material itself. Thank you. Let's take a break over here. All right, welcome back to all my dear students. Salomon versus Salomon, Wadekar Baba Sahib. We'll be just taking Miss Tiwari Radhesham has a very interesting question for us. She's written, I'm Tisha. After all the shareholders are dead, who is going to run the company? So very interesting question. So the exact sense that we have to understand here, child, is if all the shareholders have died, whosoever is running the company is not the exact question, but whether the company continued to exist or not, that is the main question. So now what will happen? Let's assume an example. There were 3 shareholders, ABC. They were driving on their way back from the meeting and they met with an accident and they died. Now they have incorporated a company, ABC Limited. Even if that company is not doing any business, because obviously it will be doing business through the shareholders or directors. We taught you that human agency is somebody who's acting behind the company, then only the companies work. So your question is absolutely right. Then how the company will work? The answer is, even if the company is not working, the name of the company ABC Limited will still continue to exist. There will be still this company which is into existence, whether it's working or not working. Later on, it might become a dormant company because it's not functioning. Then it might get redundant and the name will get removed. But the essence is that just because the shareholders have died does not mean that the company has come to an end. It will still be operational. There might be another shareholders who might join in the name of the company and take over it, or that might start the business. Another directors have taken over it. Howsoever it is going to function, or the examples that you were giving, the legal heirs might come and take over it. But the name of the company will come to an end only when application will be made to the registrar or the tribunal, and they will remove and strike off its name from the registrar of companies. So when we understand the entire procedure of registration of companies, there in detail, you all will understand how actually the company gets winded up, how actually the company is coming to an end. All right, so let me just take out the study material for all of you now, and side by side, we'll keep doing the queries also. All right. So Salomon case, we'll be taking. Makora case, we're going to take right now in a while. Anything else? If the company is limited by guarantee, members are, yes, Ms. Shreya Tiwari, then it depends upon the amount of guarantee which is mentioned over there in the agreement. So if you have decided that I will be only, my liability will only be 10,000, then you will only be liable up till rupees 10,000. Again, Shreya Modi, another question, common seal. This will be understood when we go to the study material. Mr. Kevin was having another question. Applicability of Act to insurance, you do not understand. Okay, so Insurance Act, generally for all the insurance companies, I told you Insurance Act is applicable, but wherever the provisions are inconsistent. So whether it's a Banking Act, Insurance Act, Electricity Act, wherever they are not, both of the provisions are coming, then Companies Act provisions will always overrule, because that is the main act which is applicable to any company. All right, Mr. Nishant, Shaika, that's great. How will the new shareholders get admitted? So how the shareholders are joining in, how the directors are appointed, Ms. Shreya Modi, that is part of your CA intermediate syllabus. So when we go to CA intermediate, then we understand, as of now, we simply have to remember that the company will still remain open and functional, and howsoever the shareholders are running it, it still remain operational, even if there are no shareholders or directors, because it has a perpetual succession. So the example over there was given to explain you the meaning of the word perpetual succession, which means continuity of existence. Change in members will not affect its existence. So whether the members come or go, it does not matter. Existence of the company will still remain as it is. All right. Separate legal entity. So separate legal entity, I told you there is a very important case law, Makora versus Northern Assurance. Company is different, members are different. Every member can contract with the company. So all the members have been given the right, they can incur liability in behalf of the company. Company is capable of owning and enjoying and disposing of property. So आप कंपनी के नाम पे भी प्रॉपर्टी खरीद सकते हो, कंपनी केस भी फाइल कर सकते हैं, कंपनी के अगेंस्ट भी केस फाइल हो सकता है. Why? Because it is a person which is different from the subscribers to the memorandum. Who are the subscribers to the memorandum, children? Many of you have written lines in the queries also. Nobody pointed out this one. Do you know who are the subscribers to the memorandum? So memorandum is the document which we submit as a promoter when you're opening the company. You are known as a promoter. You know who is a promoter? Promoter is a person who has come up with an idea of opening a company. So unless and until you have not opened the company, how can you become a shareholder? So first you're a promoter who has come up with an idea of opening a company, and then the promoters will make this document a draft memorandum. So they will sign this memorandum. So when they sign this memorandum, they become subscribers to the memorandum. Only once the company is registered, it has incorporated, then only you become the subscribers, only become the members of the company. So it says a company is a person which is different from the subscriber. So if I am a promoter and I want to set up a shoe business and I want to set up XYZ shoe company, then I will make a memorandum of XYZ shoe company and I will sign that. So I will be subscriber to the memorandum and XYZ shoe company will be my company. So we both are different. So can I have the insurance of this company? So can I have XYZ shoe company insured in my name? Can I take the insurance in my name? I told you XYZ shoe company is different, Harleen ma'am is different. So if I go to the insurance company and I get the property of the company signed in on my own name. So I said, this is my company, shoe company, and please give the insurance in my name. Law says, come on, this is not done. You cannot have insurable interest. वो different है, उसकी property different है. तो अगर आपको XYZ shoe company की insurance चाहिए, तो आप XYZ shoe company के नाम पे लोगे. Harleen ma'am की insurance, Harleen ma'am की property के लिए होगी. Company की property is different. That's the main essence, separate legal entity. So Macora versus Northern Insurance Company Limited के केस में क्या हुआ था? Macora was the holder of all the shares of a timber company, except one, means 99 shares were being held by of a timber company. There was a company, a wood company, timber. It is a kind of wood. He was doing sale and purchase of wood, and he was the major shareholder. He was holding 99% of the shareholders of that company. And he was a creditor of that company also. पैसा भी company से उधार उठाया हुआ था. M insured the company's timber in his own name. So whatever timber, so the company's timber is the company's property. You are different, Macora is different, and the timber company is different. But the insurance that he has taken is what was actually happening. Earlier, he was a sole proprietor. So when you're a sole proprietor, entire assets, whatever you're owning, will be taken the insurance in your name. Now he converted that timber business into a company. So now when company was formed, so actually the insurance, the property, the timber, entire property became the property of the company. It was to be insured in the name of company itself. But he forgot to make such changes and the insurance was taken in his own name. Then fire occurred. I told you what is the role of insurance company. If any losses are happening, insurance company will come and will pay you the money for that. So you keep paying the premium regularly to the insurance company. And whenever any damage or destruction happen, as per the cover, that policy that they're following, they pay you the damages. So the timber was lost in fire and now M wanted to claim the insurance compensation. तो M insurance company वाले के पास गया, उसने बोला जी मेरी insurance के पैसे दे दो, मैंने तो आपको प्रीमियम दिया है, मेरा ये इंश्योर्ड था और ये डिस्ट्रॉय हो गया. ऐसा ही होता है जब हम फोन या कोई और की चीज इंश्योर कराते हैं. इंश्योरेंस कंपनी ने कहा वी आर नॉट लायबल टू यू because no shareholder has any right on any of the item of property owned by the company. You only have legal or equitable interest. Insurance company saved themselves. They said, look, this insurance papers, property of the company has destroyed and insurance is in your name. Had your personal property got destroyed, we would have paid you the insurance, but you should have got yourself, this company should have got itself registered for this insurance claim. Had it been Macora's company limited, timber company limited insurance taking, then they would have given, but it was Macora, individual shareholders' name was written over there in the insurance cover. Therefore, they said that you cannot even have any kind of insurable interest also. The insurance has to be taken in the name of the company which is getting the property because the company's property is different. I told you, company is owning, enjoying and disposing property in its own name. Although the capital and assets are contributed by the shareholder, company becomes the owner. Shareholders are not the private owners. आप ये नहीं बोल सकते कि अगर आपने रिलायंस में शेयर्स ले लिए हैं तो अब मैं रिलायंस का मालिक बन गया, फिर तो हम सब लोग जितने भी शेयर्स लेते हैं हम सब ओनर्स बन जाएंगे ना. We are not the private or joint owners. We are just a part of the shareholders. The property, the major Although we are only contributing towards the assets, but the company is the major owner of all the capital and assets. That's why it's said that company has a different existence because uske naam pe sari cheezein aa jati hain. And those who were asking me perpetual succession, all those assets will still continue to be held by company. That's why we have to get it legally registered, and legally you have to get its name removed also. Understood? Macora versus Northern Insurance Company Limited. Those who are sending n number of queries, do we have to learn the entire case law? It is not mandatory to learn the case laws. What is important is to understand the case law. Now this word should not bother you about the insurance and all. Northern Insurance Company was the insurance company which was giving, so the Macora has filed a case against the insurance company. So insurance company said, दो बातें सिर्फ याद करनी है. Macora has got the timber insured in his own name. Since the timber was not insured in the company's name, लिख लो. Macora has got the company's timber insured in his own name. Since the timber was not insured in the company's name, therefore, insurance company refused to pay the compensation. The insurance company refused to pay the compensation because the shareholders' property is different and company's property is different. Had the property been insured in the name of company itself, then they would have legally claimed the money. ये last line understanding के लिए थी, लिखने के लिए. ठीक है, अब ये मत कहना repeat करो, दोबारा देख लेना session में. Perpetual succession we have done n number of times. I hope no doubts in perpetual succession now. Let's quickly go through because we have many case laws to go with. Okay, limited liability. Company is a limited liability in case of the company limited by shares. So you said I will take up the shares at the cost of nominal value of the shares held by them. So they were rupees 10 per share. And let's assume you have paid rupees 8 per share. So you have taken up 1,000 shares in the company. You have taken up 1,000 shares in the company and the shares were at the rate of rupees 10, bacha, but you have paid rupees 8. So you have already taken up the share capital of 8,000 rupees. Now, how much is the unpaid value of the share? Out of 10, you have paid 8. So what will be the unpaid value? The unpaid value is rupee 2. So now if any shareholders is asked to pay anything, he will not be asked to pay more than rupees 2. So that means applications can be invited for 2,000 rupees more because this is only the amount which is unpaid on the shares. So your liability is limited only to the amount which has been left unpaid on these shares. If it was 10 rupees per share, you have paid the entire 10 rupees, no existing liability. If your still unpaid value is there, then only up till that unpaid value, company will call you to pay the liability. Otherwise, your liability is limited to the extent of shares you're holding. So if you're holding 1,000 shares at the rupees of 10, you have paid entirely, that means your liability is done. Clear ho gaya? Company limited by guarantee, you said that I am only going to pay rupees 10,000 and that also when the company goes into liquidation. Liquidation means, liquidation is another name given to the winding up. Winding up of company is known as liquidation, means closure of the company. ये सारी डिटेल आप इंटरमीडिएट में पढ़ोगे कि कैसे क्लोज होती है, कैसे लिक्विडेट होती है. फाउंडेशन में तो जस्ट सिंपल vocabulary you have to learn. These words do come up. All right. So Companies Act is, children, very scory. Abhi somebody was writing, Mr. Kevin was writing that although law is lengthy, but it's very interesting. So very good. This is what I want all of you to find it amazing, interesting. Then only you enjoy studying it. So keep making notes. Limited liability, company limited by shares, only to the value of shares. Anything unpaid on the shares will be liable. Company limited by guarantee, only the amount that I have given the guarantee. The members are liable only till the amount they have guaranteed. Number 2 point, that too when the company goes into winding up. Simple. Unlimited liability, you have to tell me. What is the meaning of unlimited company? The liability of the members is unlimited. What is the meaning of unlimited liability, children? You have to tell me. If your share capital is not sufficient, then you have to even bring your Yes, personal assets from the home in order to dispose of the liability. Word unlimited हमने पार्टनरशिप में अच्छे से पढ़ा हुआ है, वही सेम मीनिंग है. तो अनलिमिटेड कंपनी में शेयर होल्डर्स की जिस तरह पार्टनर्स की लाइबिलिटी अनलिमिटेड थी, पर्सनल एसेट्स आर टू बी हेल्ड लायबल इन द सेम वे. इन केस ऑफ अनलिमिटेड कंपनीज द लाइबिलिटी इज लिमिटेड, not limited only to the shareholding. Personal assets can also be called from home. Clear? All right. When we do types of companies, again, we will be discussing these 3 points. So don't worry. Okay. Just keep revising and understanding along with what we are doing. Artificial legal person. Now comes up your most important point. It says the company is an artificial person. Directors cannot control the affair. They act as its agency, but they're not agent of the members. Remember, in partnership, you all were mutual agents. You as my partner do something, I will also be liable. I do something, you will be liable. This is the basic feature that we understood. Remember the air tickets that we have booked for the business trip. Even if I have forgot to pay, the person might come and ask for you to the payment unless and until it is not for the personal use. That is the principle. But can we do the same feature in company? It says no. Company can act through human agency, but come on, we are not agents of each other. A director is doing any actions, director is liable, company is doing any action. Directors cannot control the affairs of the company. They are not the agents of the members. You cannot say that the directors and shareholders are having the principle of mutual agency. No, they do not have. Directors can either on their own or through common sale can authenticate its formula. Directors क्या करेंगे? सिंपल एक कॉमन सील लगाएंगे अपनी कंपनी की और अपने पेपर साइन कर सकते हैं. उनको कोई शेयर होल्डर्स की परमिशन या फिर म्यूचुअल एजेंसी लायबल होने की एक दूसरे पे ऊपर जरूरत नहीं. They cannot control the affairs of the company means that they cannot take entire thing in their own hands. Company is totally different. Okay, so it's only a human agency, means human people through which the company is acting, but company has its own separate legal existence. It can have bank account, it can raise loan, incur liability, and this is the meaning of separate legal entity, children. Company के नाम का bank account. So company's current account, company's saving account. So whatever money is going, coming, it is happening in the name of the company itself. It can do anything which a natural person can do except going to jail or marrying or practicing a learned profession. Individual नहीं है, ये याद रखना है. शादी नहीं होती है कंपनी की, ना ही कंपनी जेल में जाती है. अब ये जेल वाला बात से क्या बताना चाह रहा है आपको? चलो थोड़ा फन कर लेते हैं. कह रहे कंपनी कैन नॉट गो टू जेल. हाँ, शेयर होल्डर्स डू एनी फ्रॉड, then my dear, law is going to come and he will say, remove this company, these are the shareholders, you will be dragged to the jail for sure if you do any kind of illegal actions. You know, the shareholders, people started taking the advantage of this thing that law में तो लिखा हुआ है company अलग है, shareholders अलग है. तो shareholders अब drugs का business कर रहे हैं, उन्होंने company खोल ली. तो criminal lawyers came and they said that this is illegal. And they started taking precaution. Please hold a company liable. We are so different. Company is different. They said, come on, if you're doing any such kind of illegal actions, we're going to lift the corporate veil and company and shareholders will be considered as one. So it's coming up when all the cases in which the corporate veil can be lifted and shareholders can even be sent to jail. All right. But before that, 2015 amendment says that we have removed the name and common seal from section 9. Section 9 gives you the silent features of companies. Out of that and common seal, the fifth word has been removed. Why they have removed? Because this amendment provides that the documents to be authenticated by a common seal should be required to be done only the company opts to have a common seal. So अब आपको ऑप्शन दी गई है, अगर आपने कॉमन सील रखनी है तो प्लीज आप रखिए, बट a company which does not have a common seal must make sure that minimum 2 directors are signed the papers. So if I want to finalize the deal, I cannot sign it unless and until 2 directors have signed it. And if I have a company secretary in my company, then 1 director and the company secretary. Wherever the company secretary is appointed. Generally, people who go for law and CS course, they go for this kind of job profile, company secretary. So company secretaries also are supposed to sign. So there are many legal cases, companies where it is mandatory to appoint a company secretary. So if you have appointed a company secretary, then that company secretary and director should sign the papers. Where you have not appointed and you do not have a common seal, then 2 directors will sign. Okay, so let's take immediately a very nice quiz. Let's take an example. There was a company, ABC Limited, having directors M and N as their directors. And the company has a company secretary, Miss X is a company secretary, Miss Z. So now who all needs to sign the documents of the company? ABC Limited company needs to sign the documents. The common seal has to be shown. The authorization has to be shown. There are two directors, M and N, in the company. And there is a company secretary, Ms. Z, who all need to sign the papers. Tell me. There are two directors and there's a company secretary. Then how it will happen? I'll need to stop the screen share so that I can see your answers. Otherwise, I'm not able to see your answers. So let me see who all has sent the correct answer. Definitely, Nishit Shakya, studying for 12 hours a consistently day, that's fine. But you have to make a proper timetable. Then only you can decide how you have to complete it. Vadekar Sahib, general public is a subscriber. That's correct. Personal assets are used to pay off the liability. Ms. Tiwari, that's bilkul correct. Radhesham, that's correct. MNN or by MNN and Ms. Z. Okay, Ram Sayyed, that's correct. Purva Joshi saying company secretary. Aditi is asking what is common seal. So common seal means the common signatures that you put for any papers of the company. It's the authorization given for any documentations of the company. Two directors or one director, everybody is giving very, optional answers. Ki ma'am, isme se choose kar lo, aapne jo bhi answer choose kar. Excellent, Miss Nikita. Only one director, M or N, and the company secretary, Z. That's absolutely correct. So again, somebody is saying, Alfie Dangal is saying company secretary or two directors. Again, you're giving me a choice. So why, children, I was taking up this example. Please now again read this line very carefully. It is giving you the option that, where are we? If the company has appointed a company secretary, please, then we have to have a director and the company secretary. Read this last line. It says wherever the company has appointed. So if I have appointed Ms. Z, then one of the directors, either M or N, can sign the document, and the word and is here. Now it is mandatory for Ms. Z to sign the documents. So if I don't have any company secretary, M and N are signing, absolutely fine. If I have a company secretary, that is Ms. Z, then either one of the director, that is M or N, and the company secretary has to sign. Likh lena ye example and write the answer also so that you remember these kind of notes. All right. Now the corporate veil, members are shielded from the liability. क्यों देता है कॉर्पोरेट वेल का मीनिंग क्या है? ये जो शील्ड मैंने बोली है कंपनी एंड शेयर होल्डर्स में, ये क्यों आती है? इट सेज दैट दिस इज द कॉन्सेप्ट which tells you that liability of company is different and liability of shareholders is different. It simply tells you that members are not liable for those errors. Company कुछ गलतियां कर रही है तो company भुगतेगी ना. हम as a shareholders we are not liable. Such an amazing concept of corporate veil theory. But before we proceed in corporate veil theory, this Salomon versus Salomon, one of my favorite case law, which I told you when we were doing partnership. Today, we are going to discuss about this case law. It seems to be very huge, but the moment you will listen to me, we'll discuss in points, it will become very easy. I can guarantee you about that. But then I want full concentration. अगर हम नींद में, सुस्ती में ऐसे बैठ के सुनने वाले हैं, फिर नहीं समझ आएगा. Attentive, sit straight, and then take full interest in the nice, interesting story that I'm going to tell you. Okay, so corporate veil simply tells you that the company is different from its members. So how this principle was laid down? How do we decide it? This decision was taken by Supreme Court judgment by Lord McNaughton. So McNaughton ने decide करा था कि company different and shareholders different है. किसके base पे? Salomon versus Salomon and Company Limited के base पे. It laid the foundation of the concept of corporate veil. Now, what happened in Salomon versus Salomon? There was a company, children. House of Lords means Supreme Court has laid that the company is different and separate. House of Lords is the foreign country courts that they call is House of Lords. So they held that the person is different and company is a person different from its members. There was a person, one named Salomon. Salomon एक बंदा था, एक individual था जो कि एक shoe business करता था. Shoe का favorite मैंने रखा हुआ है आपका हाँ. He was actually a sole proprietor, and then he thought, like I have narrated a story to you in the beginning, that let's form partnership, then LLP, and finally he wanted to expand his huge business, and he opened a company. He wanted to invest more money, and he opened a large scale company. So once Salomon incorporated a company, and the name of that company was Salomon and Company Limited, with 7 subscribers. How many people? With 7 subscribers, consisting of himself, his wife, 4 sons, and 1 daughter. How many people? 4, 5, 6, 7. So don't you think it's a family business? He himself, his wife, 4 daughters, 4 sons, and 1 daughter. तो ये 7 बंदे थे और इन्होंने एक कंपनी खोल ली, Salomon and Company Limited. Very interesting. So it seems as if the family only is involved. Company took over the personal business assets of Salomon. So Salomon was a sole proprietor. He's selling his business to the company, purchase consideration being paid 38 pounds, and Salomon is taking up 20,000 shares and debentures of 10,000 pounds in the company. So he took up how many pounds? He has took up 20,000 shares of 1 pound each. So 20,000 pounds he has taken. This is just the bifurcation, how the purchase consideration was paid off. Okay. So he has taken this 20,000 shares and 10,000 pounds debentures in the company with a charge on the company's assets. So that means these are secured debentures. When we create a charge, that means he has taken up, it is a kind of loan, it is a kind of secured debentures that he has taken up. And the balance in cash, so 8,782 was taken up in cash. So this is how he made the payment for the business that he has sold and company that he has formed. So this was the bifurcation of 38,782 bonds. Understood, children? 20,000 के उसने shares ले लिए and 10,000 के उसने secured debentures ले लिए उस company में, and balance 8,000 का cash pay कर दिया. Subsequently, the company went into liquidation. अब क्या हुआ? And wife, daughter and son ने took 1 share each. तो एक share उनको भी दे दिया. 4 sons, wife and daughter, उन्होंने भी एक share ले लिया company में. And major shareholder is 20,000 shares he himself has taken. So Salomon was the major shareholder. And the company went into liquidation due to general trade depression. General trade depression means there were losses coming up, or company was not doing very well, and it went into liquidation. उन्होंने कहा company बंद कर दो, नुकसान हो रहा है. There were unsecured creditors to the tune of 7,000 pounds. अब जब company wind up होती है, what do you have to do? You have to make the payment to the outsiders, all those who have invested in the company. All those bankers who has given loan to the company, their payments have to be given back. You have to pay the secured creditors, unsecured creditors. This is what we generally do. It said that Salomon could not be treated as a secured creditor in respect of debentures held, as he was the managing director and one-man company, which was not different from Salomon. And it was a mere sham and fraud. So क्या झगड़ा क्या शुरू हुआ? Now this is the fight. This the unsecured creditor से लेकर fraud तक जो उन्होंने बात बोली है, this is about the fight that they are mentioning. What happened is, children, when company goes into liquidation, we have to pay first the secured creditors. ये आपको मेरे से ज्यादा पता होना चाहिए, आपने पढ़ा हुआ है इसको accounts में. And then we pay the unsecured creditors. Am I right? And then balance is given and divided among the shareholders and repayment of capital. All this kind of thing happened. Okay? Balance is divided. or repayment of capital depending upon the equity shareholders have to be paid first or preference shareholders. That is altogether a different story, and balance is further divided. The general thumb rule that I wanted to share you is first secured creditors are paid, then unsecured creditors, and if then anything is left is given to the owners or the balance is divided among the members. All right. This is what we follow as the general rule. Now what happened was the company went into liquidation and they have to pay. There were unsecured creditors standing over there, 7,000 pounds. All right, we have to pay 7,000 pounds to unsecured creditors. But there was a secured creditor of the company. Salomon, children, remember Salomon has taken 10,000 debentures, 10,000 pound debentures he has taken, which was a charge created on the company's assets. I told you it's a secured debenture. So generally what we should follow is the company is going into liquidation and there were only assets which were left, 6,000 pound roughly. And this entire 6,000 were given to Salomon, saying that he is the secured creditor of the company. The unsecured creditors immediately filed a case against the company. They ran to the court. They said, look what this Salomon is doing. He has his own wife, 4 sons, and his own daughter. They're all doing a home business. And now when they're going to liquidation, instead of paying our money back, he has taken the entire assets to himself. They should be dividing whatever is left after paying our money. Are you understanding? Their contention was this. Unsecured creditors got very angry. So law said, hold on. This is what we have to do, the payment format. Whenever the company goes into liquidation, we have to see whether we are making payment to the secured creditors. And after that, we pay to the unsecured creditors. And if any balance is left, needs to be divided among the members. So here, Salomon was a secured creditor. And my dear unsecured creditors, remember, company is different. This Salomon is different. Here, he is not given the money because he's the owner. He's given back his money, which the loan that he has invested for the debentures of 10,000 pounds. So it was a kind of a loan that he has given to the company and a charge was created on the company's assets. So that is kind of a secured creditor, secured loan that he has given. Therefore, we need to pay his money back first because he's a secured creditor. Since nothing was left, there was only 6,000 pounds and 10,000 he has already taken as a secured creditor. So it was money was given and nothing was given to the unsecured creditors because nothing was left. That's why they filed a case. But Supreme Court held this judgment that whatever has been done has been correctly done because Salomon was a secured creditor. Not because he's the owner of the company. That's why we're giving him back the money. He is getting the money because he's secured creditor of the company. And on the basis of this, they have clarified that Salomon was different and Salomon and Company Limited that he has formed is different. Even if all the family members are taking up the share, he has proper purchase consideration was done, proper company was incorporated. So it does not make any difference whether your shareholders are your own family members. If you are investing in a company and you are a secured creditor, your money will definitely be returned back first, no matter you are the owner or you're not the owner. So whosoever is the secured creditor will get his repayment first, just because the company and shareholders are different. So it was clearly established that the company has its own existence. Shareholders cannot be held liable for their actions. And whole of the corporation theory is based on the separate legal existence. It says a company, Lord MacNaughton ne fir finally ye conclude kara tha that company is not an agent of the shareholders. It's not that you're making the company act on your own actions. Company is different, shareholders are different, and the entire money was given to the Salomon. And it was held that this has been correctly done and justified. Now the question arises whether we can lift this corporate personality. So this is what I've been mentioning. Lifting the veil means disregarding the corporate entity and trying out the legal facade behind it. कई बारी हमें legal face, उसके पीछे क्या असलियत छुपी हुई है वो देखनी पड़ती है. Where the courts ignore the company and concern themselves directly with the members or managers, corporate veil is said to be lifted. It is only in appropriate cases that the court can lift the corporate veil and not in every case. So it was held since everybody started taking the advantage of this thing, like they said that Salomon was given back the money, so we should also be given back our money, and they were doing illegal kind of frauds kind of things. So law said, look, court has the right to lift your corporate veil. It is only the corporate personality which is the main existence. Although whole of the corporation is based on this separate legal entity, but wherever we find that you are not using this phrase correctly, we will lift this corporate veil and we'll try to hold the real managers behind who are running the company. So lifting of corporate veil, children, means disregarding the principle of corporate personality. And here the company is legal and separate from its members. But when we lift it, it is regarded as one. So let us do the cases in which the corporate veil lifting can be done. The first important topic is when you are an alien enemy. So children, आपने Indian Contract Act में पढ़ा होगा. Can we do any kind of trading or contracts if we are an alien enemy? Yes or no? If you are in US and if I'm in China, let's assume that US and China are not into cordial relationships, then can US citizens do any kind of business transactions with Chinese if they are having World War kind of situations, or if they're alien enemies, then can they do any kind of contract? Yes or no? Shreya Tiwari is the first one to say, no, ma'am, we cannot trade with the alien enemy. That's excellent. So as per Indian contract, you have studied that you cannot trade. Similarly, the Companies Act tell you the first thing that you have to find the real character of the company, whether you are co-enemies or friends. So if X and Y country are having a war kind of situation among each other, and then they try to, if X country and Y country are into world war, then it says the citizens of X cannot do any kind of trading or cannot do any kind of business with Y country. Now, the leading case law in this was Daimler Company Limited versus Continental Tire and Rubber Company. इसकी भी बहुत इंटरेस्टिंग स्टोरी है. सैलोमन की स्टोरी समझ आ गई ना. अब इसकी भी स्टोरी समझ के फिर 2 मिनट का ब्रेक दूंगी, फिर बाकी 2 केस लॉस करेंगे. ओके. There was a company, Daimler Company Limited, and this company was formed in England, having all the German citizens. क्या बोला मैंने? इसके सारे जो citizens थे, it was the German citizens. And this was the time when the First World War was going on. And Germany and England, this Continental Rubber Tire Company is an England company. It was having all the English people. And German citizens have formed this company in England only. Now, when the World War was going between Germany and England, the relationships were like an alien enemy. They were not having cordial relationship. There was certain amount of money which was to be taken from the Continental Tire and Rubber Company. So law in this case said that Daimler Company is a German company. So Daimler Company said, no, why are you saying German company? We are the German citizens. The company which we have formed is the England company. So company is different. We are different. Please, हम आप German citizens को company के साथ मत जोड़ो. हमारी तो company England company है. And जो हमने पैसा recover करना है वो भी Continental Tire से है जो कि England company है. So we should be given our money. So now law says, why do you think, children, that alien enemies should not trade? The reason being, if I'll take the money from England, so Germans were also fighting against England only. So don't you think that I will utilize the same money in my economy in using for the war against your country? So law says alien enemies cannot trade. I will earn something from your country and I will use the same money investing in my nuclear power and other kind of things, and I'll be throwing bombs in your country. So I'm doing very illegal thing. So if the affairs are under the control of people of an enemy country, then you cannot do any kind of trading. So here people who are really at the hems of affairs, means who are really handling the company, have to be seen. So since Daimler Company was entirely handled by German citizens, even if it was formed in England, the people who were handling were German citizens. Therefore, German citizens and the Daimler Company were treated as one, and corporate veil between them were lifted. Hence, they could not recover their money from Continental Tire and Rubber Company. Today, we are having cordial relationships. We can do the trading. The moment the war situation comes, we are not supposed to do the trading with the country which we are having a war kind of situation. So let's take 2 minutes break because I have to go through your queries also in between, and just read these 2 case laws and we'll do another 2 case laws over here. concept. And Ukraine and Russia is absolutely the correct example. Tiwari Radhesham, obviously, they companies cannot trade because they're into war or any kind of situation. Akshay Kumar Bambania is saying line to line answer is compulsory. No, it's never compulsory. It's not mandatory that you have to line in the same language. You can make it in your own words, but you should not change the sense or the meaning of it. Okay, it should remain the same. Parties incompetent to enter into contract, sexual living. Excellent. Darshan, Aditya, Mahavir, very good. Yes, Nishit, Shakya, it depends if the country with which you're trading is in a cordial relationship, suddenly a war situation comes, then even if the German citizens were in England, therefore they would treat it as the one company. You cannot say that our England company is different, we are different citizens, please allow us to trade. They will not allow you because they will lift the corporate wing. Lisa Jain is saying last point, alien enemy wala. Okay, you should have written which point is that. I will look into that. All right, so everybody's clear. Secured, Aditi Salvi. So secured traders were those who have actually provided some security for the loans that they have given or the charge that they have created against the assets. So simply in that case, though, you have to creditors are also debentures. Yes, Alfie Tangal, that's correct. So debenture holders are also considered as the creditors of the company. So if I have given a kind of a loan money that I have given to the company for initial start, so whenever that and also security has been provided for the same. So at the time of winding up, those secured creditors are paid before paying to the unsecured creditors. Okay. Radhesham is saying Salomon was smart. Okay, that's correct. He tried to be smart because he was investing money. That's why you're saying him. Good. So you have understood this concept. Let's quickly wind up the other two case laws also. And let's go and understand the last point that you're asking. For this purpose, the court may examine the character of the persons who are really at the helm of affairs of the company. So this line basically, Lisa, means that the company where you're trying to take any action and you're trying to hold the like German and England company, you were trying to hold them one. So it's very important to see who are the people who are behind the affairs of the company. You cannot simply say that this is England company. Okay, England company is trading with the Continental Tire, which is another England company. So it's okay. You have to see what is the real intention, the character of person, जो लोग उसको handle कर रहे हैं, वो देखना जरूरी था. तो जब उन्होंने वो लोग देखे कि वो लोग जर्मन सिटीजन है, तो उसको जर्मन कंपनी मान लिया गया, डेमलर को कॉन्टिनेंटल ऑलरेडी इंग्लैंड कंपनी थी. समझ आ गया. अब डिंशो मैनेजी पेटेड पे आ जाओ. बहुत इंटरेस्टिंग केस लॉ है एंड फेवरेट ऑफ माय स्टूडेंट्स. It says to protect revenue and tax. So if you are trying to act over smart and you're creating different kind of companies just to evade income tax. Evade means just to avoid taxes. So you all know tax is your legal duty. In CA Intermediate, you'll be studying taxes also. Maybe in BCom, BBA, you have studied tax. What is the meaning of tax? It is the revenue of the government. Whatever income you're earning, you have to pay a tax to the government on the basis of that income. The different basis of calculations are given. All right. अभी के लिए सिर्फ इतना समझ लेते हैं कि डिंशो मैनेजी पेटेड एक बंदा था जो कि टैक्स एवेड कर रहा था, फ्रॉड कर रहा था ना. उसने टैक्स पे करने के बजाय व्हाट वाज ही डूइंग? द कंपनी वाज नॉट अ जेन्युइन कंपनी एट ऑल. ही बाइफरकेटेड हिज एंटायर इनकम. ओके, लेट्स मेक नोट्स. डिंशो मैनेजी पेटेड, व्हाट डिड ही डू? ओके, okay, he created a company. He was earning huge income by the way of interests and dividends. So he must have purchased few shares and other mutual funds in different companies, and now he was getting huge interests and dividends on such kind of income. So he was earning huge income by the way of interests and dividends. What did he do? He invested this entire income in 4 different companies. क्या करा उसने? सारी जो इनकम आई, he invested this entire income in 4 different companies and took back this money as a loan from these companies. So on one side of his balance sheet, he was showing that all money invested in 4 different companies, and the other side was showing the loans that he owes to outsiders, that is the loans that he has taken from the company. So he was balancing his balance sheet like this. What he was actually doing, he was simply circulating his money in order to avoid paying taxes. So now if you have huge revenue, huge income, you'll pay tax on that income. So he thought that I don't want to show my income in the books of accounts. I will invest it in 4 different companies. And then again, from those companies, he has taken a loan. So he is merely creating a sham. Sham means a fraud company. So creating a sham means he was just creating a fraudulent company. He was just trying to fool the courts and laws that I'm investing my money, and then he's taking loan from the same company. The same amount was taken back as a loan also. So here the income was transferred back to the SEC by way of loan, means court decided all these private companies were just a fraud, were a sham, and the corporate world were lifted to decide the real owner. So law says we have to decide who is the real owner. That's why corporate bail is lifted. So वो कहते हैं ना, पर्दा हटाना और देखना कि असली गुनहगार कौन है. So who was the real person behind this whole was Dinshaw Managji Pettit. So he was the sole proprietor. He was the owner who was doing all these kind of frauds. And the court said that we do not consider these companies as a legal company. They're just a sham. They're just doing a kind of a cloak kind of thing. They were doing just a fraud. So corporate world was lifted, and Dinshaw and all these 4 companies were considered as one. Dinshaw ने कहा होगा ना कि ये 4 companies है, companies different, I am different, तो companies को आप पकड़ो अगर companies गलत कर रही. उन्होंने बोला आप ही हैं इसके behind, तो आपको हम defaulty held करेंगे. All right. All right. So Dinshaw Managji Pettit is very, very important. Most of the time examiner gives you whole of this case that I've written over here for you as a picture, and questions are asked. To avoid any legal obligation, has another case law, that is Workmen of Associate Rubber Industry Limited versus Associate Rubber Industry Limited. So there was a worker of this company, Associate Rubber Limited, who filed a case against the company in which he was working. So this worker went to the court and they said that, look, this company is earning huge profits, and then there is a legal duty, if you're having huge profits, to pay bonus to the employees. And instead of paying bonus to us, they're investing in their subsidiary company. So that just to show in the books of accounts that we're not left with much of the money and a bonus was not given. So let's read what happened. To avoid a legal obligation means even if you try to take any legal obligation is not fulfilled, then also the corporate bail will be lifted. So here they were just forming the company subsidiary purpose. The purpose of forming a subsidiary company was to reduce the amount to be paid by way of bonus. So Supreme Court said, please come on, you're just investing the money in a subsidiary company so that you don't have to pay much of the amount as bonus. Therefore, the corporate bail was lifted. A company purchased shares of B by investing 4,40,000 rupees. The dividend was shown in the profit and loss account year after year. And then for the purpose of calculating the bonus, company transferred the shares of B to C, a subsidiary wholly owned by it. So just for the calculation of bonus, they immediately invested and transferred the money. Dividend income did not find place in the profit and loss of A Limited. Therefore, the surplus available for the bonus got reduced. So they were just trying to do a fraud. Whatever money was there, whatever profits they were earning, actually those whole of the profits were to be used for calculating the bonus to be given to the workers. But they, since they have invested the money for the subsidiary company, which was wholly earned by another subsidiary company, therefore they were just trying to evade the bonus amount which was to be given to the workers. Hence, this lifting of the corporate bail was done, and the company that they were forming and the owners, they were considered as one and the same thing. All right, so this was one to avoid legal obligation. So Supreme Court, again, this is also Supreme Court judgment. So it's very, very important to understand and learn these Supreme Court judgments. Nobody is asking you to learn them word to word, but a basic understanding is very, very important. Formation of subsidiaries to act as agents. Again, if the company is just forming and, as an agent or trustee of its members, he is investing in money, then the company loses its individuality as a whole. Here, the principal will be held liable. So whatever you're forming as an agent company, then you will be liable for their actions also. All right. So last one, company formed for improper or fraud conduct to defeat law. Very, very important and interesting case law, Guilford Motor Company versus Horn. So what happened in this case law was, I'll explain you like this. There was a company, Guilford Motor Company. So the fifth one was like this. There was a company, Guilford. I hope it's visible. Motor Company. And they had an employee, Mr. Horn. So he has been working with Guilford Motor Company for a very, very long time. And when this employee was leaving this company, they said that, Horn, look, now you're leaving Guilford Motor Company. So children, you remember certain restrictions which we try to put on the employees who are leaving a company, or maybe the partners who are restrictions on trading after leaving the organization. So if you remember that you are not allowed to solace the same customers, or you're not allowed to work the same business in the in and around area. This is what we learned. We generally, when any employee or any partner is leaving the organization, we tell him. So Guilford Motor Company told his employee Horny that you're leaving my company. Please don't try to solace my customers. Solace means don't try to attract my customers. Since you have been dealing with them, so don't try to compete the business with me, and you're not allowed to work in the same business in and around area for a certain period of time. So all these agreements were made with Mr. Horn, but Mr. Horn formed a company and did all these illegal acts. He solicited the customers, he went to the old customers, he attracted the customers for his own company also. Whatever restrictions were imposed, he just worked against them. So here he is trying to defeat law, means he was not following the law, he was not following the provisions which are given under the formation that they have done of the contract. So Guilford Motor Company filed a case and they said, look, this Horn is trying to cheat us. He is doing the competing business. He promised to us that he will not be competing with us, but now he's taking our customers also. So please wind up this company, close this company. So court went to Horn. Court asked Horn that this is illegal. So you know what Horn replied? Horn replied, I am different. My company is different. We have corporate veil between us. So go and hold the company liable, not me. So all of you have to tell me before you leave the class, was he correct in saying that? Or what should have been done? What should have been the real intention? Mr. Horn said that, I am different, my company is different. So Harleen ma'am has told you there's a separate legal entity concept, company is different, shareholders are different. So now this company is doing fraudulent act, this company is going and soliciting the customers. So how can you hold me liable? We have corporate veil between us. So was his intention correct or not correct, or what should have been done? Please tell me, send me your answers. I will read out your answers and then tell you what should be the correct answer. What does Mr. Kevin brushed aside means? From where have you picked up this line? So it has a different intention depending upon the line from where you're taking. No, he's not correct. If you do any fraud, the corporate veil will be lifted. Punjabi Asif says, yes, he was correct. No, he was not at all correct. How can you say that he was correct? So all those who have said that, no, ma'am, he was not correct is the correct answer. Why? Because if you are trying to defeat the provisions of law, if you're trying to do any kind of cheating and any kind of fraudulent act, then the corporate veil will be lifted and you, Mr. Horn, and the company that you have formed will be treated as one. So Guilford Motor Company was the previous company where he was working. This is what I wanted to tell you over here. The new company that is formed, that is the fraudulent kind of thing that he was doing. Yes, Devan is correct. Radhesham is correct. Lisa is correct. Tiwari Radhesham is correct because he's trying to do the fraud and cheat and misuse the corporate law. That's correct. Yash is correct. Yes, Vatikar Sahib, his contention was on bilkul theek. That's absolutely correct. Dinshaw case. Okay, so Mr. Kevin and Dinshaw case, we have simply understood that he was just trying to bifurcate his income. So brushed away means he was just bifurcating his income, huge 1 crore income he was earning. He was investing 25 lakh, 50 lakhs, and other different lakhs and putting it in different companies. And then he was taking back the money from the companies as a loan. So he's just brushing away, he's just putting the money away and then taking back. So in general terms, we call it circulation of money was happening just in order to avoid the taxes. So when you see his profit and loss account, there were no profits, nothing revenue to be shown in order to compute the taxes. So that's why in Dinshaw case, he was held liable. Yes, Shriya Modi, correct. So all of you have sent the correct answers. We have 2 minutes more in case you have any queries, you can send it. And the homework is, we have done 5 case laws today. Nakora, Salomon, Dinshaw, Daimler, Guilford Motor Company, and that associate workman rubber also. 6 case laws we have discussed. No, it's not necessary to learn the case laws as it is, but basic understanding जो मैंने बोला है, आपको समझाया है, that should be grabbed by you. You should know the meaning of the case laws. You should have a basic understanding. In the next class, I'm going to ask you MCQs on the basis of these case laws. So revise it, learn it. Learn तो करना ही, पढ़ना तो पड़ेगा children. Law cannot be done without, studying or doing anything. So all those who keep asking, ma'am, 12 hours, 13 hours, see children, in CA foundation, you have to give almost equal importance to all the subjects that you are studying. So if I just take care of my law, I'm not doing VCR or I'm not doing accounts, then also the things will not work. So equal balancing has to be given. As far as law is concerned, if you want my opinion on that, make a proper timetable for all the acts. Say, for example, if you have started Indian contract in the month of December, by now you should have revised it at least once. It should have been done. Sale of goods, partnership, LLP, all those you have done, it should have been done once. Now the second revision of, along with these companies, you should start revising your Indian contract. By the time we end the company's Indian contract, second revision should be completed. After that, the 1 week, pick up the sale of goods, partnership, and LLP, the small acts. Companies try to learn it as along with it. And then the 3rd week, you'll be revising your companies. That means 2 times the syllabus is done and then the final revision. If you will not plan, you will not write, you will not make a timetable and the things are in the air only, then they will remain in the air only and May will come and you'll be wondering here and there. Start writing it down now, make a proper chart, make a proper timetable. I should know where I am if I'm doing any chapter, what is left. Like few of you have written very beautifully today in that query session that, ma'am, we have revised sale of goods and partnership. And after that, we picked up mock test papers and wow, we were finding it simple. So great. Only the mock test papers, if you pick up after completing the chapter, then only it makes sense, children. If today you'll start picking up the mock test paper of companies, I'm sorry, you'll not understand anything. So first complete the chapter with me, have the complete understanding, then do the mock test papers with me, then things become clear. All right, so let me see if there is any query. Otherwise, all the best and revise. Yes, Aditya Darshan, he was wrong. That's correct. That's why now it will be treated as 1. Salomon versus Salomon कंपनी का लास्ट पॉइंट मैम हिंदी में स्वाति गिरी. हिंदी में उसका मतलब मेन जो इंटेंशन है वो ये है कि आपकी कंपनी अलग है, सैलोमन अलग है. आप ये नहीं कह सकते कि सैलोमन के घर के बंदे ही हैं, कंपनी चला रहे हैं, तो आप इसको पैसा क्यों दे रहे हो. अनसिक्योर्ड क्रेडिटर्स नाराज हो गए. उन्होंने बोला आपने तो सैलोमन को ही पैसा दे दिया, वो तो खुद ही ओनर था. तो कोर्ट ने कहा हमने सैलोमन को इसलिए पैसा नहीं दिया क्योंकि वो ओनर है, क्योंकि वो सिक्योर्ड क्रेडिटर है. हम लॉ में, अकाउंट्स में, लिक्विडेशन में जब पेमेंट करते हैं तो सिक्योर्ड क्रेडिटर्स को देते हैं, अनसिक्योर्ड क्रेडिटर्स को देते हैं, फिर जो बैलेंस पैसा बचता है ओनर्स में बैलेंस डिवाइड हो जाता है. सो जस्ट बिकॉज ही वाज अ सिक्योर्ड क्रेडिटर, द मनी ही इज गिवन बैक टू हिम. Company is different, shareholders are different. He was considered as one of the shareholder who is different from the company. समझ गए? All right. Thank you, Shriya, Aryan, Nikshit. Thank you so much, children. Thank you, Shriya Tiwari. I hope you all have enjoyed the session and see you all on Wednesday. Thank you, all of you. Goodbye.